So the advantages of the living trust is that it avoids probate and your assets must be transferred and named in the name of the living trust. And usually your attorney will give you a certification of trust that has the proper title. And at our office we have letters prepared for people to take to their bank, their investment advisor, their life insurance as to how beneficiaries should be set up and named to be the living trust. If you have a lot of life insurance, there may be a separate, you may want a separate trust for that, but that's the subject of another seminar. The trust controls who receives the assets, and that's why it's so important to have them titled in the trust, because the trust will benefit those you love and not the people you don't want to benefit.
There's a question.
Yes.
Are you talking about the insurance policy outside of your trust?
In some cases, there's a tax reason to have the insurance policy separate from the trust. So that would be dependent upon your total value and whether you have a taxable estate or not. So there's a different strategy for holding insurance proceeds if you have a taxable estate.
Almost the reason for people having to pay estate and gift taxes is because they didn't do the proper planning. You can get your entire insurance policy out of your estate and not have it be taxable if you go to an estate planning attorney. I want to just kind of go through a little bit as to the types of wills that are in existence.
Yes. We have something called a holographic will. And many people think that's the answer to all their problems because they don't have to go to a lawyer and they don't have to pay any fees. If you're going to do a holographic will, it has to be all in your own handwriting. It's written out in your handwriting, it's signed by you, it doesn't have to be witnessed, and it should have a date on it because the last holographic will is the one that's supposed to be followed. And if you change your mind, you shouldn't have several different wills with different dates, without dates.
And it's the most litigated form of a will. And you can see why. You know, because it's handwritten in the person's own handwriting, and sometimes people don't write real clearly as to what they want to have happen. So consequently, Howard Hughes, was his written will upheld?
Still being litigated.
Is it still being litigated?
I think parts of his estate are still being litigated.
Wow. Okay. Stay away from holographic unless you're in a bar and absolutely need to change your mind. Write it on that napkin. Okay. Statutory.
Statutory is provided by the California State Bar and the probate code, and you have to, again, you can sometimes get it at a stationery store or you can download it from the California State Bar website. And it has certain provisions. You have to fill in certain parts. You have to sign your name. There are 2 witnesses required, and you have to follow the rules exactly or it will not be upheld.
It's the second most litigated form of a will. Avoid it because nobody is completely like all you have to do is fill in the blank. And so people do cross out words, and as soon as you do that, it's no longer valid. What is a formal will?
The formal will is what most attorneys prepare, and that's the one that's usually very nicely done on a computer or typewritten. You do have to have 2 witnesses who have to follow certain rules and be present at the time that you sign it. Usually it's initialed on every page, and that states your name. It usually includes your marital status, and that's where you list all the children, whether you want them included or not. They must be listed if you want to disinherit them, because otherwise they could be considered an omitted or pretermitted child.
Remember, even like a will and a living trust, when you're thinking about this, one of the things the attorney is going to ask you is, what if one of your children were to die? What would you like to have happen? Would you like to have it go to your children? To your grandchildren? Do you want it to go to that wonderful spouse? What do you want? But in a will or a trust, those are the kinds of questions you are going to ask. Is that correct?
That's correct. So we always want to benefit the children, the spouse, and do it the way you want, so that everything is very clear.
By the way, the two witnesses have to witness your signature. If this doesn't happen, the will is invalid. I had a situation where the testator forged one of the witnesses' signatures, causing the whole thing to be invalid, and the estate went intestate.
The other thing that has to happen is that they both have to sign at the same time. They both have to be there. They have to see you do it. And if somebody is incapacitated, can't sign their own name, it is legal to make an X, but then one of the witnesses has to write next to it and say they saw that person make the X and that was such and such a person.
What is a pour-over will?
The pour-over will works with the living trust. The reason you have to have it is so that if some assets accidentally got left outside of the trust and they don't pass by operation of law, if they can be poured into the trust, $100,000 or less, real property less than $20,000, the pour-over will says put it into the trust. Of course, if the assets are over the limits, there will be a probate.
Talk a little bit, we didn't talk about intestate succession. What does it mean and what happens?
Intestate succession is where you are one of the 70% that has no trust or will. You never signed anything and you pass away with no trust or will. And this is where the state of California has a plan for you, and they say how much goes to your spouse, how much goes to your children. It's kind of, if you have a spouse and one child, it's 50-50. If you have more than one child, the spouse gets a third, the children split up 2/3, and then they go down from there with their who inherits. And the surprising thing is that stepchildren, foster children, all kinds of children are included in the definition of children. And then it also goes to relatives who may be in-laws, etc. So if you don't want one of those pictures like we showed up here, the nightmare heirs, you need to make sure that you have a plan so that the state of California doesn't say what your plan is. Worst case, all the assets go to the state. Last point on witnesses for the will. They should not be a son, a daughter, a niece, a nephew, or a spouse who's going to inherit. Because when you have what's called an interested witness, that can invalidate the will. Then it's considered that the person was under undue influence, fraud, duress, all those terrible things. And so you need to have two disinterested witnesses who are not going to inherit from your estate.
Is it possible to have co-executors in a will?
Yes, it is. And that's a good check and balance. If you're concerned and you have two children, you might want to put them on as co-executors. So they both have to be in charge together, and one can't take 100% of the assets and leave 0 for the other one.
Yeah. My experience in that area is don't do it. Because it ends up they're in a battle. And so you may want to talk to both of them and just choose one. Talk a little bit, I know we're going into this area a little bit soon, but talk a little bit about having a trust protector in a living trust versus the trustee.
That's a wonderful question. The trust protector, and that's something that I appoint myself as long as the clients don't object. And this gives an independent person the power to remove trustees and replace them if a trustee turns out to be fraudulent, incapacitated, embezzling money, or any reason that a court might take a trustee out. And the reason for doing this is so that the heirs don't have to go to a lengthy court proceeding. If a trustee is fraudulent, embezzling, going through all the money, then they may have to go to court. to replace that trustee. And it's a lengthy, expensive, time-consuming process.
So the trust protector can fire and hire a new trustee. Now, the issue under a will, when you have a co-executor or just an executor, you're already going to be in front of a judge. So the and a protector is not necessary. So because you're going to be in front of a judge, full disclosure, accountings, etc. So, but in a trust, it's very private. And that way, having a trust protector there keeps an eye on the trustee.
So usually the trust protector does not suddenly say, oh, I'm the trust protector, I'm going to rush in there and change your trust or do this and that. It's only when somebody notifies me that there's a problem. The most frequent reason I've been asked to do it is where somebody becomes incapacitated and can no longer handle it. And so then it may be necessary to remove that person. Another case, a daughter was buying a 5-carat ring out of the trust account, and so we removed her as a trustee. But these are the types of reasons that myself, as a trust protector, would remove a trustee. It's always for good cause. Yes. If you have extensive personal property such as oil paintings or antiques or jewelry, you may want to have it appraised, and that's the best way to do it. Other than that, you won't know. So if you accidentally have that Renoir in the attic, that would be a nice thing to happen, but sometimes it does happen, and you need to have an appraiser.
Do you use in your estate planning documents a general assignment of the personal property to the trust, or do you leave the will to distribute the personal property items?
We do a general assignment of the personal property to the trust, and then sometimes there's a memo that lists who gets what jewelry, who gets what oil paintings, etc. It saves a lot to have it in the trust, but still it needs to be valued if you have extensive collections, because it will add to the total, and the IRS will be very interested in that.
By the way, personal property seems to be the lightning rod for an immense amount of family disputes. Mom intended this to be mine. She told me that, but there is nothing in writing. And so it's a big
I do the list. I encourage my clients to get the list together and tell me who's supposed to get the grand piano, who's supposed to get that 5-carat diamond, who's supposed to get the oil painting by Picasso, and it saves a whole lot. And they do argue. One son who received his father's medical practice, he said, "Oh, if Dad had only left me his gold watch." So those things do mean something to the kids, and try to do it. If you know that the kids like certain things, try to do it according to their likes and dislikes.
And give the trustee, whomever it is, some flexibility as to how to distribute the personal property. Because it may be that everybody can come into the house and take, okay, you take one item, you take one item, and everybody's peaceful. Others need to have everything formally appraised, and they need to be in separate rooms and then given all the personal property items. And you never know how they're going to react until it actually happens. Yes?
With the new generous limits on gifts, why not make those transfers while you're living?
It's an excellent idea. I would recommend it highly. You get the pleasure of making the gift and seeing whether or not the person appreciates it. And then if they don't appreciate it, you can knock them out of the rest of the estate. So I highly recommend that. Christine, thank you so much. It was great.